In about half of the United States, you can be arrested for one simple thing: refusing to tell a police officer your name, not for a crime, not for fighting back, just for staying silent about who you are. But cross into the other half of the country, and in the very same situation, you can stay silent, turn, and walk away, completely within your rights. Same country, opposite rules. So, which one is true for you? Do you actually have to show police your ID? The honest answer comes down to three things, and almost nobody gets all three right. Here's what most of us assume: that there's one clear national rule. There isn't. Whether you have to identify yourself depends on where you are, which state, on what you're doing, walking, driving, or riding as a passenger, and on whether the encounter has legally escalated from a casual conversation into something more serious. And there's one more trap hiding inside the question itself. Showing your ID and telling an officer your name are not the same thing under the law. Keep those two ideas apart, and this whole confusing mess suddenly starts to make sense. Start with escalation, because it's the master key. Almost every police encounter falls into one of three levels. The first is a consensual encounter, just a conversation. You're free to decline to answer and free to walk away. The second is a detention, sometimes just called a stop. The officer isn't letting you leave, but you're not under arrest. The third is an arrest. The single most useful thing you can say out loud is a question. Am I being detained, or am I free to go? That one sentence forces the officer to tell you which level you're actually at. So, when can an officer legally detain you in the first place? The rule comes from a 1968 Supreme Court case, Terry versus Ohio. It says police can briefly stop you only if they have what's called reasonable suspicion, a specific describable reason to think you're involved in a crime, not a hunch, not a bad feeling, an actual articulable reason. This kind of stop is so common, it has a nickname, a Terry stop. And here is the floor that protects you. In 1979, in Brown versus Texas, police stopped a man in an El Paso alley simply because he looked suspicious in a high-crime area. They demanded he identify himself. He refused and was arrested. The Supreme Court threw the conviction out. Being in a rough neighborhood, looking nervous, walking away from an officer, none of that by itself is enough. Without reasonable suspicion, police cannot force you to identify yourself. The demand for your name has to ride on top of a lawful stop. It can't conjure one out of thin air. But suppose the officer does have reasonable suspicion, a real, lawful stop. Now, what can they actually make you do? This is where your state matters enormously. Roughly 24 states have what are called stop and identify laws. In those states, during a lawful stop, you can be legally required to identify yourself. In the rest of the country, you generally can't be forced to, even during a valid stop. So, before you know your rights, you have to know your state. The case that settled all this involved a man named Larry Hiibel standing beside his truck on a Nevada roadside in 2004. A deputy investigating a report asked him to identify himself. Hiibel refused 11 times. He was arrested and fined $250. His case went all the way to the Supreme Court, which ruled 5-4, that a state can require you to identify yourself during a lawful stop. On its face, that sounds like the government won a sweeping new power. But read the fine print, and it's far narrower than it looks. Because here's what Hiibel did not require. It did not require him to hand over a driver's license or a card or any document at all. Simply saying his name out loud would have satisfied the law. Your name, it turns out, isn't a document, it's a word. That's the distinction almost everyone misses. And it isn't an accident. Back in 1983, in Kolender versus Lawson, the court struck down a California law that vaguely demanded credible and reliable identification, precisely because it was too open-ended. The laws that survive ask for one thing: your name. So, let's put it together in the three situations you'll actually find yourself in. First, walking down the street. If it's just a conversation, a consensual encounter, you don't have to answer anything, and you're free to leave. If you've been lawfully detained and you're in a stop and identify state, you may have to give your name. And that's the whole obligation. Nowhere in America are you required to carry an ID card just to walk around. Second situation, driving. And here the rule is refreshingly simple, and it's the same in all 50 states. If you're behind the wheel and you get lawfully pulled over, you must produce your license, your registration, and proof of insurance. Why is driving different? Because driving is a license privilege you signed up for. When you got that license, you agreed to the rules that come with it, including showing it on request. Walking down a public sidewalk isn't a privilege anyone granted you. It's simply something you're free to do. That distinction, by the way, is where a popular piece of internet misinformation completely falls apart. You may have seen videos claiming that if you call yourself a traveler instead of a driver, you're somehow exempt from licenses and ID laws. Courts have heard that argument and rejected it every single time. In the real world, it doesn't end the stop. It usually ends in extra charges. The privilege is the privilege, whatever you decide to call it. Third situation, and the murkiest. You're a passenger in a car that gets pulled over. The driver has to show a license. But do you? Generally no, not just for being in the seat. An officer usually needs a separate, specific reason to suspect you of something before they can demand your identification. In one federal case, a court said that demanding a passenger's ID isn't even part of the purpose of a traffic stop. In another, the judges on a single panel couldn't agree with each other at all, which tells you just how unsettled this corner of the law really is. So, what actually happens if you refuse? Here's a twist that catches people off guard. Even in stop and identify states, refusal is often charged not under the ID law itself, but under a much broader obstruction, or resisting an officer law. Larry Hiibel, remember, wasn't convicted under the identify statute. He was convicted of obstructing a public officer. And in states with no stop and identify law, police sometimes reach for those same obstruction charges when someone won't give a name. Whether that's even legal is genuinely contested. Courts in different states have gone in opposite directions on it. And this isn't just theory. There are documented cases of people arrested for nothing more than declining to identify themselves. A man standing at a job site, a woman who filmed a traffic stop, where the charges were later dropped because there was no probable cause to begin with. In some, the officer's own report admitted it. These cases are exactly why knowing which of the three tiers you're in matters so much. The very same silence can be perfectly legal, or land you in handcuffs, depending on facts that have nothing to do with what you actually did. There's one more wrinkle worth knowing because it's being fought over right now. The long-standing rule is that stating your name is enough. You don't have to produce a physical card. But in 2026, Alabama's Supreme Court ruled the other way, holding that when simply saying your name isn't enough to confirm who you are, officers can demand the document itself. That decision clashed with an earlier federal appeals court, which had read the same kind of law to require only a name. Supporters of the stricter view say officers sometimes genuinely need the card to know who they're dealing with. Critics say these laws, on their face, only ever asked for a name. It's a live disagreement, and, like so much here, it can depend on where you live. Now, layer on modern technology. More and more states are rolling out digital driver's licenses that live on your phone. And that raises a brand new question the courts haven't fully answered. If you hand an officer your phone to show a digital ID, have you just given them permission to look through the rest of it? The Supreme Court has already said, in Riley v. California, that police generally need a warrant to search your phone. And several states have passed laws making clear that flashing a digital ID does not count as consenting to a search. But it isn't universal, so if you use one, it's genuinely worth knowing your state's rule. Here's a closely related right people ask about constantly. Can you record the police through all of this? Broadly, yes. At least 7 different federal appeals courts have recognized a First Amendment right to film officers doing their jobs in public. But, and this matters, the Supreme Court has never squarely ruled on it. And not every court has agreed. The safe version. You can generally record as long as you're on public property, and you don't physically interfere with what the officers are doing. And these rules keep changing, law by law. Ohio just passed a new statute, set to take effect in the fall of 2026, that goes further than most, requiring both drivers and passengers to give their name, address, and date of birth when an officer reasonably suspects a traffic violation. It's brand new, not even in force yet, largely untested, and almost certain to be challenged in court. It's a reminder that this isn't one settled national rulebook. It's 50 states, each writing and rewriting its own. So, strip it all down, and it comes right back to those three questions. Where are you, a stop and identify state, or not? What are you doing, walking, driving, or riding along? And has the encounter escalated? Are you just having a conversation? Or have you actually been detained? Answer those three, and you'll know, in almost any situation, whether you're required to say a single word. Do you have to show police your ID? The truthful answer is, it depends. And now you know exactly what it depends on. This is general education, not legal advice for your specific situation. And the details shift by state and by the year. But understanding this one framework explains an enormous amount, including why two encounters that look almost identical on video can end so completely differently. Step back and you can see the whole arc. A right to be left alone unless police have a real specific reason to stop you. A power recognized in 2004 to make you say your name, but only your name, and only during a lawful stop. And a patchwork of state laws still being written today, pulling in every direction at once. Where you stand, it turns out, really can depend on where you're standing. Now you know,